22nd. It is 1:02. We're having difficulties with some of the electronics, so we have what we have. Darlene, do you want to give us a roll call, please?
Okay. Councilmember Cervantes?
Here.
Councilmember Manley?
Here.
Councilmember Molina?
Here.
Mayor Pro Tem Hewitt?
Here.
Mayor Davis?
Here.
Planning Commissioner Keith?
Here.
Planning Commissioner Champenois?
Here.
Planning Commissioner Brittingham?
Here.
Vice Chair Cundiff?
Here.
Chair Barron?
Here.
Okay, we're joined by the city manager, Cobo, Assistant City Attorney Kearns, City Clerk Gertis, Planning Director Lucia, and we have a secret consultant, Wendley Worthy. Thank you for coming. And then with that, we'll go to Jeff. You want to lead us in the pledge, please?
Be honored to. Please stand. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
My mic is flashing, so I'm like that. Yeah.
Okay, we have communications from the public. And
Mr. Mayor?
yes, sir.
There's not the normal communications from the public like at a regular meeting. As this is a special meeting, they will speak at the item. So once the presentation's done, then that's when the speakers will come up.
Really? Okay.
Yep.
So, let's move on like we know what we're doing.
Well, good afternoon, Mayor, members of the City Council, Chair Barron, members of the Planning Commission, members of the public. Thank you for coming to today's workshop on land use and entitlement. Before we get started into the presentation, we're going to do introductions of the panel. So I'll start with myself. I am Will Coble, the city manager. Been city manager here for almost 5 months. I have over 20 years of experience in local government, mostly focused on finance. I was a governmental auditor for 3 years, worked for the Cucamonga Valley Water District for 6 years, City of San Bernardino Water Department for 2 years, and the City of Orange prior to coming to the City of Calimesa for the past 8.5 years. I have a bachelor's degree from Cal State Fullerton in business administration, concentration on accounting, and a master's degree in public administration from Cal State's Dominguez Hills. And I will now hand it over to Kelly to introduce herself.
There we go. Good afternoon. Thank you everybody for being here. My name is Kelly Lucia. I'm the planning director for the city. I have been working for the city in some capacity or another for about 7 years. First as a private consultant. Sorry? Closer to the mic. Closer to the mic. You got it. So first as a private consultant and now as the city planning director. I have a bachelor's degree in public policy from UC Riverside and a master's degree in urban and regional planning from Cal Poly Pomona. I have worked in many stages of entitlement and development for the city throughout the past several years. So projects like JP Ranch, Singleton Heights, Summerwind, Mesa Verde, and others. I have been involved in the implementation of those projects, permitting, inspection, and entitlement work. I'll pass it over to Brendan Kearns. Thank you.
Hello, Mayor and Council and Chair and Planning Commission. My name is Brendan Kearns. I'm the Assistant City Attorney. I've been with the City Attorney's Office for over 7 years, and I've devoted my career to municipal governance, housing, and land use. Before I focused on representing cities, I started my career in Washington, D.C. doing housing and community development work for the federal government. I find this stuff so important and so fascinating, and I'm delighted to be part of this panel. and I'll pass it over to our CEQA consultant.
I've never had to talk in a microphone because my voice is so loud, so you might have to tell me to keep it down. I thought Will was going to introduce me, so I didn't really plan to have to do that, but that's fine. Anyway, good afternoon, and I'll say Happy Earth Day because it is that. My name is Wendy Worthy, and I have been in the environmental field for 28 years, first in Texas doing the National Environmental Policy Act, and then in 2000 came to California. I've been doing CEQA ever since in some form. I have a master's degree in biology, but I learned very quickly that I was interested in all the topics that get covered by CEQA, not just biology. I also taught CEQA for 15 years at University of San Diego, so I'm going to kind of rely on that teaching skill today to talk about CEQA and try to explain it and simplify it down. Thank you.
So, growth has been happening in the city of Calimesa, or actually in this region, for the past 15 to 20 years. That's very evident to our neighbors to the south, the city of Beaumont. Their 2010 census had their population at around 11,000, 12,000. It has now peaked over the 50,000 mark in just 10 years in the 2020 census. Calimesa's growth has lagged a little bit behind that, but it started hitting us first with Singleton Heights, then JP Ranch in the first phase of Summerwind. Now, while there may be a focus from the public on development that requires decision-making from the Planning Commission and or the City Council, there are many other types of applications that are what are called permitted uses that go through a ministerial review, which we'll explain what that means later. But I think it's important that we understand what all those things are and all the processes that happen so that everyone in the public that is interested in this kind of stuff knows the fundamental process. Ultimately, the City Council, the Planning Commission, and staff understand the gravity of these decisions and the impacts that they have. Now, first, I do want to acknowledge that we are living in a time where trust in government has been eroded. If you look at polls, they consistently rank in the 20%. As a matter of fact, the moving average right now, there's a Pew Research poll that continually polls about what the confidence in government is to do the right thing, and that's at about 20%. And obviously, there's a lot happening in Washington that contributes to that and the things that we see on the news and the TV every day. And quite frankly, even here at the local level, we've seen people like Robert Rizzo of the city of Bell, like Alan Kapanikis of the city of Beaumont, that don't do anything to help our cause to actually, conduct sound public policy and conduct the people's business. But the other thing that I don't think government does a very good job of is educating the public and making sure that the public understands the how and the why. A lot of times we see the what, we see the result of these decisions, and we get involved at public hearings and we see different notices that go out, and those are checkpoints that people are engaged in the process, but there's not a big understanding of what happens behind the scenes. How do we get from a project application to something that's going to be in front of the 10 of you for consideration? And that's really what this is about today, is to talk about the how and the why of a lot of these processes and how things happen. We hear things, we see things in social media, we hear at the council meeting, things like, why is the planning department even considering X or Y project? Why doesn't the city bring this certain business here? City, you need to put a Trader Joe's in. That's the one we hear all the time. And not just in Calimesa, but that's everywhere. Staff is biased in their still working the kinks out of the new process. Sorry about that. And I think we need to understand. I do want to address one thing about incentives for getting things through. It's one thing that we've read. That to me is an affront on the ethics of staff, and that's something that we take very, very seriously. And that's something that we want to make sure that the public understands, that whatever comes in front of us, staff does not get to decide which projects we process and which projects we don't process. As a matter of fact, you don't want that. You want staff to be objective. You don't want staff to be subjective and picking and choosing. That is up to the policy makers. Staff level, we are policy implementers, and that is our job to do. Our job is to follow the law, follow proper process, follow municipal code, and all those things. Our goal is that you can take the information you learned today about our process and apply it to any project that comes before you in the future, and be able to form opinions with the understanding of how this works as a foundation. We do not expect, and nor should it be this way, that the public is going to agree with every decision made after you hear this information today. But we do want to make sure that our engagement is a productive one and one that can be talked about in substance based on a foundational knowledge of this process. So some of the things we're going to cover, this is a very high overview of what we're going to cover today. But there are a lot of state laws and frameworks that must be followed. But we need to start, though, with a fundamental understanding of the planning basics, because a lot of the processes refer back to these concepts. So I think it's important that we know those things. We'll then walk through the process an applicant must go through and all the hoops they have to jump through, and there are a lot, and that's why that's part of why the process takes so long. I think developers would tell you that we're professional and that we're good at our jobs, but they wouldn't say we don't hold them to our standards, and we hold them accountable and we make sure that they follow the processes properly. And although on the next slide I'll lay out the basics of the roles of the various stakeholders and participants in the process, this will be a theme throughout the presentation, so we're going to talk about those things as we go through. Then we'll talk about some of the things that are considered when a decision is required. So here are the various stakeholders, and the order is important because the city staff does a lot of the heavy lifting, but the city council and planning commission are obviously the decision makers in a lot of cases. The public's obviously a very integral part of this, and as a matter of fact, if you looked at an org chart of any city, whether it's Calamasa or any other, the public's at the top, right? Because the public is ultimately who vote in the city council. You know, there is accountability between the city council and planning commission. The planning commissioners are appointed by the city council, and so obviously there is some oversight there. So if there are a lot, you know, if we see a lot of things that are being appealed to the planning commission coming into city council, decisions being reversed, city council is going to start thinking, what is the planning commission doing? And that's just the way it is. The applicant obviously has a role in this process. They're afforded due process, as we're going to get into later. They have standing in the projects, but they're also the only party that can make promises and agree to conditions. So if the city council goes, you know, I want you to do X, Y, and Z in addition to what's listed in the staff report, you can have that back and forth. Only the applicant can agree to that. We can't, and if it's not, and sometimes that could be a deal breaker. And they're also most knowledgeable about the project. So if you have questions about the project and about certain aspects of it, they're the ones that are going to be able to answer the questions. So again, though, I want to emphasize public input is very valued, and I've worked at other cities, and I know for a fact that public input is very important to all 10 of the people sitting before you. So with that, I'm going to hand it off to Kelly to get us started on planning basics.
Thank you, Will. Okay, so whenever you discuss land use and development, specifically in the state of California, you're going to start with the foundation of a general plan document. What's shown on the slide before you is the cover of our most recently updated comprehensive plan, 2014 general plan. Every, again, city and county in the state is required to adopt one of these documents. And what it has is a number of required elements, which is just a fancy word for chapter, and it's considered a quote-unquote blueprint for the built environment in the city of Calamasa. It is high level, it contains detailed policies and goals for development in the city, and this is an important point, it's a living document, which means that it changes with time based on policy direction of city council. We do have 3 specific plans, which are another type of regulatory document in the city, and those 3 are the Summerwind Ranch at Oak Valley specific plan, Mesa Verde specific plan, and Heritage Oak specific plan. What those do is set unique development standards and planning criteria within a certain geographic region in the city. So here are the required elements. We need to cover land use, conservation, circulation, safety, housing, noise, open space, and environmental justice. Okay, so I found a few quotations here that I wanted to make sure we discussed today. These are quotes from the general plan that was adopted back in 2014, and I wanted to spend a little bit of time talking about where we're at in support of these goals and kind of recap what the long-term city vision has been for quite some time. So in 2014, we set forth with our general plan and said we were going to support Calamesa's transition from a small rural city to a more populous community that welcomes new residents who will live in neighborhoods in master plan areas while retaining the city's sense of community and rural identity. So that's a lot, very wordy, but I think the important point there is that we have seen for a long time that Calamesa would be entering into a transitional time. We were small and rural, and we expected that with time we would be growing. Second, our general plan set forth a principle that we would recognize the benefits of diversity in all aspects of the city, its people, its housing, and its economy, while retaining the rural atmosphere of Calamesa. So again, to hone in on some of those concepts, people, housing, and economic considerations, we should be embracing diversity of different land uses, people, and projects. Finally, our general plan sought to ensure the long-term viability of Calamesa, both from an economic standpoint and from the perspective of the built environment, including infrastructure systems and resources such as land, water, air that are critical to a healthy city. So again, there are lots of changes coming to Calamesa, but I'd like to make the statement that we've seen this coming for a while. Okay, so a few slides ago I spoke about the general plan. Again, the general plan is a very high-level policy document. When you get into the nuts and bolts, the actual development standards within each planning area within the city, we're looking at the zoning and land use map and the Calamesa Municipal Code. So the zoning ordinance complements and implements the general plan or specific plan. It's a regulatory document, and it establishes permitted uses and development standards for every piece of property in the city. Can only be adopted and modified by City Council upon recommendation by the Planning Commission. So that was a lot of information to say. As a professional land use planner, when I look at this map, I see rules. So if I were to select any piece of property in the city of Calamesa, it's color-coded as you can see on the map. The different colors mean different land use designations. So where you see blue, that's probably a school or a public facility. Where you see red, that's commercial. Where you see the various shades of brown, yellow, orange, those are residential designations. And green is open space. So where if you were to fly around the city today, you would not see that all of this land has been developed, but for many, many, many years, the city of Calamesa has planned for what each and every single piece of property will contain at some point in time, so long as a development application is consistent with our development standards, our general plan designation. If any deviations from those long-standing policies or plans are requested, those come to the Planning Commission and City Council for consideration on a case-by-case basis. Okay, so there are other types of plans that exist in the planning world. We have a few in the city I wanted to highlight. So on top of our regular municipal code, we also have a downtown business district, and so that sets forth unique development standards roughly between County Line Road and Sandalwood Drive in the city. That's where we see as kind of the heart of our economic development within Calamesa. We also have a Calamesa Creek overlay zone, and we have habitat conservation plans. So I wanted to spend a few minutes talking about that because a few slides ago you'll see that Calamesa way back when was talking about wanting to make sure that we take care of our resources, such as land, water, and air, that are critical to a healthy city. So that's a critical general plan goal that we have, and we have some help in achieving that goal. So the City of Calamasa is a member agency to the Multi-Species Habitat Conservation Plan, so the MSHCP. This is a large map. I won't go into too many details, but the purpose of showing this to you today is to convey that habitat conservation is not a city-by-city goal. This is a large, widespread plan within Western Riverside County that many, many jurisdictions have signed up to be a part of. And just briefly, I'll note that those blue squares, those are called criteria cells. Within each criteria cell, it describes what type of conservation will occur there. And the intent is to provide wildlife corridors throughout all of Western Riverside County, including within the City of Calamasa. So if you were to zoom in on Calamasa specifically, you'll see here that we have a number of criteria cells that impact private property in our city. And the intention is to move wildlife between the city roughly, horizontally through the center. And what I would like to highlight on the next slide, so let me show you here, the green. Please focus in on the green. Those are lands that have already been conserved in perpetuity. The slide says lands conserved so far with an exclamation point, because this is a long-term plan with lofty and significant goals that I'm pretty proud to say Calamasa has had some really great progress towards. So again, if you look at that, see where we were hoping in the blue that we would get conserved lands. Look again in the green where that has occurred. So that has been either through sale of private land that at one point in time was approved for development. That's also through friendly acquisitions with private sellers. But the purpose of really highlighting this today is to say Calamasa has goals for open space, for wildlife corridors, for trails and things of the nature. And the development that you see occurring today is separate and apart from the city's lofty conservation goals. So our conservation goals have been met in some areas. We continue with each and every development project to strive towards additional open space lands. And it's important to see that this is in perpetuity. So the areas that you see shown in green on this map, they will not be developed, not today, not tomorrow, in perpetuity. They're held by various public agencies and non-governmental agencies. So the Riverside Conservation Authority and our partners at Rivers and Lands Conservancy have long-term title ownership over these lands. And with that,
Before we move on to Brendan, I did want to make one note back on the slide talking about planning basics with the downtown business district. So I know there's been some talk about wanting to develop Calamasa Boulevard, and that continues to be a goal of the city. The original downtown business district plan was conceived, I think, in the mid to late 2000s, and back then we had something called a redevelopment agency, and that was going to be a big tool that would allow us to do a lot of the development there and help out with that. But in 2012, the state eliminated every single redevelopment agency in the state, and along with that, the revenue source that those redevelopment agencies operated with. So that took away a funding source not only for those things, but it's something that we're going to get into later, is affordable housing. Took away from that. But a lot of these things like downtown business districts, we've seen how there's been like Uptown Yucaipa, for example. They were able to use their redevelopment tools to develop those things prior to that dissolution. And so it becomes a much bigger challenge for us to move forward with a lot of the plans that we'd like to have with that. It's still a goal of ours, but I just wanted to point that out, that it got a heck of a lot harder about 10 years ago when that happened.
thank you. So Brendan's going to spend some time talking about housing, and I just want you to have in the back of your mind as he talks about the various housing mandates that the city is subject to, that our open space goals, are separate and apart from any of those housing laws that we're subject to. Thank you.
Yes, and you really can't talk about land use in Calamasa or in the state without talking about housing. And obviously everyone is concerned about it. I've lost so many friends and acquaintances to affordability, and I send them postcards off to Portland or Austin or wherever else. And in recent years, legislature has woken up to this issue. So about 5-6 years ago, there was a declaration of a housing shortage in the state, right? There's this sense that there is a severe shortage that has to be addressed and that immediate action must be taken. So what did that mean? First, financial assistance. The state has invested billions in various programs, various funding sources to develop housing of various different sorts. I know the city is always monitoring opportunities for us to take advantage of such grants, and there's, in addition, the counties also issue some funding for that. But what we're going to focus on more today are amendments to state law, right, that apply to the city and govern how land use and planning processes occur here. And primarily 3 categories, right? Various laws that streamline the approval process for housing. They expedite it and they reduce a city's discretion to potentially deny a project, right? The second one is to ensure that sufficient land is zoned for housing, right? Because you could put money into it, you could limit the city's abilities, but if there isn't land on which housing can be placed, it won't be that productive. Lastly, I want to talk briefly about all these measures that provide for greater concessions and waivers and other possibilities that can reduce the cost of housing development, right? Because often you'll hear this thing, oh, I'd like to do that project, but it won't pencil out, right? So the state has wanted to provide ways to give developers flexibility. In practice, it's meant a litany of new state laws and substantially strengthened existing state laws. And just a short list here, there are dozens more that we have to navigate each day, and more added every legislative session. And now we could do 3 hours just on this slide, and we won't. I just wanted to briefly touch on kind of examples of how the thrust of all this legislation is affecting planning and land use for Calamasa. So first, the housing element law. A big takeaway there, of course, is the city's obligation to identify additional zoning for housing at different levels of density, right? Housing element requires many other things, eliminating barriers to development of housing, implement programs to facilitate housing, but a key thing here is ensuring there's sufficient property for housing. The no net loss law. This is a law that basically limits a city's ability to approve a project if the resulting project would have fewer units than the number of housing units that currently are on the site. The Housing Crisis Act is a relatively new law. It does a lot of different things, but the key goal is honing in on several behaviors cities have had over the years that have delayed or prevented development of housing. One example is there's now a restriction on 5 meetings for a city to consider a housing project, because there is a sense of, okay, proposals would get continued and further studied and delayed again and again and again. And so the state said, no, you get 5 meetings and you have to render a decision. Next, accessory dwelling units. I think we're all fairly familiar with that concept, but it's basically second units, or third in some cases, that are put in the backyard of an existing single-family home, or added on to some multifamily projects, things of that sort. The concept here is gentle density, right? So you're on a lot, you might go from 1 unit to 2, 1 unit to 3, but you're gradually adding additional units to the jurisdiction's housing stock. Okay, and we've got the Housing Accountability Act really limits the bases on which housing can be denied by a city. Density bonus law. If you devote a certain amount of a project to affordable housing, you have a lot more discretion under the zoning code. You can ask for certain zoning restrictions to be waived, and you can have more density, as the name suggests, than what otherwise would be permissible on that site. And lastly here, SB 35. If you meet certain requirements, the housing project is approved in a streamlined basis ministerially. I'll get to what that word means later, but a key part of that is there's very limited basis to deny it, and you do not have to comply with the CEQA process that can substantially delay a project and increase costs.
And Brendan, before you move on to the next slide, I think just something more fundamentally that needs to be understood is that the state is what allows local jurisdictions to govern land use. So in other words, the state has ultimate authority. They delegate that authority to us. So it's not like we can just say, yeah, the state said this, we can't do it. They're the ones that allow us to regulate land use in the first place. And so that's why these laws can come in to limit our ability to do that.
And it's a great point. And sort of the hierarchy of law, of course, the federal government can dictate a lot to the states and local governments. The states can dictate further to the cities. So when we operate, we don't only have our municipal code governing it. We have this broader universe of laws that are on the books. And the last point here, so obviously we have this list of laws we're trying to process. They can be frustrating, they can kind of undermine some local goals and priorities, but we have seen in cities across the state very severe consequences when a city is found to not comply with their legal obligations here. I've laid out some basics. It's, things you might anticipate, right? Lawsuits by private parties, by developers, by the Attorney General's office, and so forth. For a lot of that litigation, the city may be obligated to pay the other side's attorney's fees in addition to whatever costs they have. In some extreme cases, it may limit our permitting authority, right? Typically, we would issue permits of various sorts. And if a city is found to not be complying with these laws, there could be scenarios where we would lose that power for some projects or perhaps in its entirety. Some of you may have heard in recent months about this concept of the builder's remedy. Is that familiar to any of you? Have you heard this? Okay. Well, it's basically under certain circumstances, depending on the status of a housing element and issues of that sort, a city may be found to not have the discretion to deny housing based on its consistency with local standards. So you start to see these news stories out of Santa Monica, Redondo Beach, Manhattan Beach, and so forth, of proposals that are coming in that assert that they don't have to comply with local standards, right? And that's something that can always be at issue for cities that aren't fully compliant. Lastly, we have here eligibility for state funding, right? And that's something where certain state grants, which I alluded to earlier, you cannot receive those grants if you are in jurisdictions that's been found to violate one of many state housing laws. Now I'll pass it on to our planning director to talk about entitlements.
Mayor, may I ask a question, or should we do it at the end? Okay. What's happening now as well, if you haven't covered, is the state is now suing cities that are not in compliance with either the housing element or the new laws that have been put on the books maybe 2 years ago. And so this is why our cities, the whole state of California, is fighting these new laws that come out because it controls what cities can control. So, for instance, the state is suing the city of Huntington Beach because they are not in compliance with the housing element. So there are a lot of things that go on that affect cities that are not in our control, and we have to make sure that we're apprised of those new laws and how they affect our cities. And so we spend a lot of time on that. So I know we did last year. Oh, okay. So I'm just making a statement, but it's an important statement. Thank you for allowing me to say that. We spend a lot of time on that. Thank you.
Thank you, Linda. So I just have one slide here I wanted to provide before Brendan continues discussing the types of applications. I wanted to give some examples of development projects in the city. So residential, you might be familiar with JP Ranch, Singleton Heights, and Summerwind. Retail, we recently permitted and had constructed the Marketplace at Calamasa project. That's the Stater Brothers Shopping Center off of Cherry Valley, and you'll see construction ongoing, grading and other site improvements for the Summerlin Commons retail project that's underway. For industrial, we recently welcomed Sorensen Engineering to our city. They're currently continuing with their tenant improvements. And institutional, an example of that would be the new K-8 school that was just constructed also in Summerwind. Pass that back over to Brendan.
Yes, and I wanted to lay out 3 different categories of applications that the Planning Commission and potentially ultimately the City Council may receive. And not all applications are the same, and these distinctions I'm going to identify right here can have significant legal consequence. So it's worth kind of grasping how they're different. First, we want to talk about ministerial. Now, these are applications that are objective in the city's assessment, and there is very limited basis to deny these projects as long as they comply with applicable objective standards. And what would be an example of that? So it's things that you or I could independently verify. Something like a height limit, right? We can generally reach consensus on how high 9 feet is, right? Here's some examples of ministerial applications that we might be navigating as a city. Now, in contrast to ministerial, there's what's called discretionary and quasi-judicial. And instead of ministerial context, we're talking about an objective assessment. These are applications where the commission or council may have to exercise some personal judgment, and there may not always be an agreement among all reasonable minds. A good example of this would be something like compatible with the surrounding neighborhood. One person may say, oh, this type of project is totally compatible. Another person may disagree. Their reasoning may both be sound and may both be supported by substantial evidence, in contrast to something like height, right, where you get out the tape measure and you have clarity on that. Here are some examples, right? Conditional use permits, subdivisions, things of that sort. One important thing when you're talking about these discretionary quasi-judicial applications is the centrality of findings. So you may get an application, let's say for a conditional use permit, and there is this exercise of personal judgment, but it's bound by these findings that have to be made. You consider an item and it has to meet these requirements: neighborhood compatibility, consistency with general plan policies, so on and so forth. And that is the roadmap for the decision, right? And there may be other considerations you have as a commissioner or council member, but unless they tie to the findings, they're not relevant to your legislative body's assessment. Because what we need here is to make the required findings, or not, but in either case, to ensure that the determination is supported by substantial evidence. And lastly, we have legislative acts, and now these are where there's the broadest of discretion, and typically, under almost all circumstances, no findings are required. And this is where you're changing law for the city. It's not just a particular permit or subdivision, it's about the rules of the game that will subsequently apply to all development in the city. Changing the zoning, changing the general plan, adding a specific plan, things of that sort. And when the city is operating there, it's generally a policy determination where there really is typically almost limitless discretion. Yes?
You might want to define ministerial to people in the audience. If we understand what that means, but they may not understand the difference.
I'd be happy to expand on that. So let's go back to the slide. So again, we're looking at an objective assessment, right? And so it's going to be something where the types of criteria that a proposed project has to meet are largely things, or exclusively things, that are things we can measure, things we can calculate, not things where there's personal judgment. Is that hitting the point? I think there might be something
No.
you want to explain.
Yes and no.
Okay.
Ministerial as it applies to us here in the city, comes from different places. It comes from the state, it comes from developers that are now taking advantage of the new laws that are on the books. Ministerial means a developer can come into our city and can cite a specific law, and the city has no right to stop them because it's ministerial by law, meaning it doesn't have to have city review, it doesn't have to apply to our planning commission, it doesn't have to comply with our general plan. That is something that we have planned for our city growth. So that's a very important issue whenever there's a ministerial application from whatever source, whether it's from a developer or from the state.
I just want to add to that. In general, when you look in our zoning code, which is Title 18 of the Calumet Municipal Code, it's probably it's our largest title by far, and that's just the nature of the beast. But if you look at any type, various types of use, and anything that has P in it permitted would generally be a ministerial action on those type of businesses.
And I'd like to add, typically, ministerial projects are normally processed and issued throughout the course of business at the staff level. So all of the application types that you see on the slide, it would come through the planning department to myself or Celine Sevilla, our associate planner, and we would be issuing, mostly over-the-counter type permits, sign permits, temporary event permits, etc. And when you get into the discretionary actions, is typically when you would see those come before the Planning Commission and City Council for consideration.
Thank you.
Okay, and our city manager alluded to this earlier, but it's really important to understand that under the Due Process Clause and various provisions of the Government Code, there is an obligation for the city to review proposed applications, to ensure completion, and to process the application if it's complete. And so if we fail to do so, the likely outcome will be litigation where a court would order us to process it, right, if we fail to do so. And the underlying logic of that is, okay, a property owner has an interest in this property, and they have certain rights to develop it in accordance with local, state, and federal law. And the city cannot limit their rights without a sound basis. A sound basis could be the application's incomplete, it proposes a project that's not consistent with the applicable zoning and general plan, and there's no argument for changing those standards as part of the application, things of that sort. But if we receive an application that is consistent with applicable law, it's a valid proposal, and it's a complete application, there is an obligation for the city to process it. And we started to talk about this here, the Due Process Clause. 14th Amendment, it's been on the books for a very long time. It has a lot of different provisions, but the key one here is that no person shall be deprived of life, liberty, and in this case the most important one, property, without due process of law. And this clause is implicated whenever council or the planning commission considers a development project. And here's how. So as you're taking actions that could affect an owner's property interest, you have to ensure that reasonable notice is provided, there's an opportunity to be heard, and most important for our purposes here, before an impartial decision maker. And these basic requirements will govern the city's proceedings in general. We always have to keep these in mind as we go forward. Impartial decision maker, right? The courts have recognized we all have opinions, right? We all come in with certain priorities, certain things that we feel are important, how we'd like Calamesa's future to unfold, right? What type of projects are a good fit, what's a less good fit, and so forth. You can have those opinions. Let's say you're running for council, you say, I see this way of life as important to the city, I want to promote these values, I like projects of this sort, whatever. If you're speaking with a level of generality, that's permissible. That's not going to make you typically a partial decision maker, you won't have an impermissible bias. You're allowed to have opinions. And there's a quote, from an old appellate case that talks about the decision makers don't have to be intellectual units. You can have opinions. What's more problematic is if you have a specific prejudice against a particular applicant or project that would impair your ability to decide the matter on the appropriate grounds. So, the appropriate grounds meaning like the findings that are laid out in state law, things of that sort. And I'll lay out one example here. So there's a case out of the city of Los Angeles where a planning commissioner wrote an article in her HOA's newsletter that discussed a proposed project and called it a threat to our wildlife corridor. And the court looked at that and said, there is unacceptable likelihood of bias here. It's not fair. If you've already adopted a position on a specific project, that you then weigh in on it. You have become partial, you've become biased. Due process would not permit your participation. And so it's not a good look for the city. We always want to make sure we treat applicants fairly and we don't have prejudice before particular projects considered. And I'll hand it back to our planning director.
Okay, so we spent a lot of time talking about development and land use. The exhibit shown here on the screen is a handout that we provide to our development applicants. And we do have printouts here for the audience and for Planning Commission and Council if you'd like to take one home with you and study it. There's a lot of words, looks complicated, looks difficult to accomplish, and if you have that that perception of this slide, you would be right. Land use and entitlement, before you can get anywhere close to a building permit, it's typically years of work that goes on between the applicant and staff. So you'll see that there's a flow chart, there's lots of arrows. A lot of times staff and the applicants are going back and forth for quite some time on any number of project-related details. Once we get past initial review, that leads into evaluation. That projects are reviewed by the entire, every city department. And so when you see an application come before the Planning Commission or City Council, it's not just planning staff that's taken a look at it. Our fire chief has reviewed it. Our building official has reviewed it. Our landscape architect has seen it, our public works department, and a lot of times city management. We review all applications very closely, very carefully. And again, I just wanted to highlight that it takes a long time. We do the best that we can to move applications through the process quickly, but it's not easy. And so just to give a couple of recent examples, I'll keep relying on the marketplace at Calamasa. That project, in theory, received specific plan approval way back in 2005. And we went through some different economic cycles, so we didn't have an application for an actual site plan until about 2017. The Planning Commission approved the site plan in 2018. A year later, construction commenced in 2019, and we didn't have an operational shopping center until 2020. That project did open with amongst the backdrop of the pandemic for a while. We only had Stater Brothers and Starbucks were the only two tenants that were operating. But if you were to go out there today, the property owner is still doing everything they can to have a fully leased project. And so I just wanted to highlight that it takes time, and there are many considerations that go into each and every development project that's processed by the city. Likewise, a residential example, Summerlin Trails was approved under the same specific plan approval in 2005. Construction began in 2018. So we had 4 separate home builders that came in. So Lennar was the first. Lennar pulled for this model complex that you see to the right of the screen. Those were our very first model homes in Summerlin built by Lennar, followed by D.R. Horton, Meritage, and Richmond. 633 lots were fully constructed by 2022. So that was a pretty quick absorption, but it did take, as you can tell by the timeline, quite a bit of time to get from the thought The planning document started years and years and years ago, and we didn't have a fully constructed Phase 1 until 2022.
And Kelly, can you describe some of the things that happen that make these processes take so long?
Yes. So Wendy will very eloquently, I'm sure, discuss the CEQA process in just a few moments. That's the California Environmental Quality Act. So that is one of the most time-intensive processes that we undergo. We also have lots of coordination with many different special districts and other agencies. So we need to engage the help of U.S. Fish and Wildlife or Army Corps, the regional board. We engage the local tribal community. So whenever you have a specific plan or general plan that's adopted or amended in the state of California, by law, we're required to consult with our Native American tribes, and that can be a lengthy process. Receiving waters permits in order to impact stream beds, that takes a very, very long time. It takes coordination with many different agencies. And then we have our friends and neighbors to the north and south. We need to coordinate with the city of Beaumont, the city of Yucaipa. There's lots of interagency coordination that happens. I could go on and on. The water district, we have multiple water purveyors in the city, so there's considerations that need to take place between them and permitting with them as well. Caltrans, and the list goes on and on and on and on. Okay, nice segue into Wendy's section on CEQA. Just there.
Hello again. See, not used to that. So CEQA, the California Environmental Quality Act, we talk a lot in acronyms, so I'm going to try not to do that, or at least explain them out once before I go down that pathway. CEQA is, as Kelly mentioned, a component of all this. It seems like a small component to the layperson, but it's actually very complicated. It's very expensive. Obviously, as Kelly said, it takes a long time, but it's really important because it affords legal protection to the city as the lead agency under CEQA. It affords legal protection to the developers, and what I have found over time is those cities and developers, counties, state agencies that have been subject to opposition tend to get more strict with the interpretation of CEQA and also get a lot better at it. They become savvy, and they want to make sure that the CEQA process is implemented accordingly and not cut corners. So what I've done here is take essentially, so I said I taught CEQA over the duration of 15 years, like 13 or 14 semesters. I have taken essentially what my students have to listen to me talk about is about 1,000 slides a semester and tone them down into 10. So I'm going to do my best to keep it CEQA 101 and really, really simple. And I do see some faces in here that are going to know a lot of this stuff already, but there are people that don't as well, and so this presentation is more for those that are very, very beginners at CEQA. Okay, so CEQA. It is a California statute passed in 1970, signed into law by Governor Ronald Reagan. It's a statewide policy for environmental protection, requires state and local agencies to follow a protocol of environmental analysis and disclose those impacts to the public, impacts from proposed projects. It makes environmental protection a mandatory part of every process. So these processes that everybody is talking about here today, CEQA fits in there in some way. And by the way, unlike some of the other regulations that everybody was talking about, CEQA doesn't really regulate land use, it just evaluates the environmental impacts of that land use. I think that's an important point. Okay. So CEQA lead agency, in this case, that is the city, the decision makers of the city. But even though it is technically the decision makers that make up the lead agency, there's so much staff work that goes into it before it ever gets to the decision makers, which we'll talk a little bit about. So CEQA applies to any activity directly undertaken by a public agency, the city, government agency, but the city in this case. So any, I would say, public works projects, road improvement projects that the city is directly doing themselves. Activities financed by the city, and private activities, meaning development projects requiring approval from the city. So I'll focus mostly on that third bullet because that's the one that seems to be the most common that, and the one that raises concerns from the public and other agencies as well. Okay, so the general purposes, this is right out of the CEQA guidelines. And by the way, there's this lovely book that I carry around and look at, although nowadays the font's gotten so small I can barely read it with my glasses, so I'm glad it's also available online. These general purposes come right out of it, right in the beginning of CEQA when it's explaining it. So it informs the decision makers, the lead agency, and the public of the potential significant environmental impacts of a proposed project. It identifies ways in which environmental damage can be avoided or reduced, prevents significant impacts by looking at alternatives to a project, maybe reduced size, a different location. Also looks at mitigation measures, all assuming that the decision makers find those mitigation measures and alternatives feasible. It also discloses, and I think the last bullet point is the important one and why we're here today, it discloses to the public the reasons why a lead agency may approve a project, still go ahead and approve a project, even though it has or would result in significant environmental impacts. And maybe those reasons are economics, job creation, much needed revenue to the city. So sometimes projects do still get approved that have one or more significant impacts, but everybody's still going through this whole process trying to make sure that they have mitigated those impacts to less than significant. Let's see, make sure I didn't miss anything here. Yeah. Let me go through this. And one thing I want to talk about is CEQA is a process. Most people, when they think of CEQA, they only think of CEQA documents like environmental impact reports or what is actually put on paper, but it's a whole entire process. And what I mean here is the process. These 4 bullet points apply to the process, not just the documents themselves. All right. Okay. So I'm just going to give you some of the very, very basic steps. So an application is submitted to the public, to the city by a developer. Again, I'm going to stick kind of to that because that's the easiest way of explaining it. Requesting some type of development approval. And the very first thing the lead agency asks is this a project? And project has a very legal definition. Oh, test. There you go. Swords, yeah. I think it goes off after a certain amount of time or something. Anyway, so I put up here the most basic definition of project from a CEQA perspective. It's much more involved than what you see here, and it's certainly more involved than what you could find if you looked it up. It's a good break. Okay, that work? Okay. So anyway, project. The whole of the action subject to a city's discretion in this case that is also has the potential to cause a direct physical environmental impact or an indirect reasonably foreseeable physical impact. When you're looking at a project or deciding if it is the city staff are deciding if it's a project or not, they're looking at it in this case to see if it's going to cause some kind of physical change on the environment. Can't just be perceived. It's like, could it? Not, we know it will, but could it? And they need to look at it further. The other part of that is the whole action. And I put that in quotation marks because often you'll think of a project as just what occurs inside the boundary, and I'll use a specific plan as an example of that. The boundary of the specific plan, and I've gone through this many times where that's what we are analyzing is what is inside of that particular project footprint, only to find out that there are going to be off-site road improvements that the developer is responsible for, or a 1,000-foot sewer line that's off-site. So when that says whole action, you can't just look at only the project boundaries and what happens. You have to look at any other improvements that make up that whole project. So the next question that lead agencies ask, once they say, yep, it's a project, but is it exempt from CEQA? So could this application or this action that's being requested be exempted from CEQA for one of two types of exemptions. So there's a lot of exemptions, but they are categorized into two different types, statutory and categorical. Statutory, the best way to explain that one is it's a list of types of exemptions that the state legislature has come up with, state legislation has come up with, that could cause impacts. However, the benefits of those particular projects far outweigh the environmental impacts. And my favorite example on that list is the Olympic Games. So when LA went through the Olympics in 1984, I think it was, they did not have to put all of that through CEQA. And I believe it's going to be in LA again in 2028, I read, so they won't have to go through CEQA. It takes a long time, especially I imagine it would for the Olympic Games. Another statutory exemption are emergency projects. You guys probably remember when a bridge on the 10 got wiped out by floods. That did not. They needed to repair that quickly. Traffic obviously was an issue, so they were able to do that bridge under a statutory exemption. Categorical exemptions are a list of projects that they're on there, they're thought to have no environmental impact or very, very small, such as minor conversion of existing structures, restoration of historical resources. I mean, the list goes on, but again, the city says, is this a project? Can we exempt it? And the next slide is if they cannot exempt it. So let me get to that one. So this is where it gets complicated and expensive and long, is when you can't exempt a project from CEQA. So if a project's not exempt, the lead agency will either prepare or have prepared by a consultant an initial study. And it's exactly what it sounds like. You're initially studying the project. And it's I think the next slide I have is a list of topics that you look at. So there's a lot to unpack there because the initial study has, I think, last time I counted, it was over 70 questions. Very specific questions that have to be answered about any project that's going through this. And the result of that initial study is to determine which of the three main CEQA documents are going to be prepared for a project. So a negative declaration is fairly simple. There are no impacts. You essentially slap a page or two statement on there that says an EIR is not required, no impacts, et cetera, et cetera. A mitigated neg deck, which we call an M&D, we usually just say M&D, there are some impacts, but they can all be mitigated to less than significant levels. So also not easy, but relatively, definitely easier than the next one, which is the environmental impact report. The environmental impact report is the big dog. That's the one that has more than one public review, et cetera, and it applies to any projects that may have one or more impacts that cannot be mitigated to less than significant. Okay? And also the lead agency can skip the initial study if they believe an EIR is the appropriate document. So if you get a big project coming in, sometimes people just go ahead and say, let's not even worry about the initial study, let's skip right on to and just get this EIR started. Okay. So the next slide is just a compilation of the different topics that are covered in an initial study and eventually transfer into those other CEQA documents that I mentioned, one of those three main ones. This is, I won't go through like a breakdown of each one, but for each of those numerous questions that's in an initial study that transfers into the CEQA documents, there are there are inherent thresholds, if you will, I'm going to use that term, that experts, whether it's an air quality expert, a biologist, a cultural resources person, a hydrology, a water quality person, traffic is another good one. Definitely need engineers and experts for that. But those questions that are answered, if the impacts are above a certain threshold, that's when it's a significant impact. If they're below that threshold, it's a less than significant or no impact. And I think what my point here is, it takes experts to make that determination based on a lot of technical information, a lot of analysis, a lot of modeling, a lot of field studies. So those questions can't just be answered, although I have seen it happen way back in the day. You can't just answer those questions, nope, no impact, or less than significant impact. It has to be based on something. So it has to be very objective. So when the lead agent, well, I'll get to that in a second. I don't want to get ahead of myself here. Substantial evidence. I already heard Brendan use this term, but I made a slide. I did a slide out of this because this goes into everything when we're talking about CEQA. So the second bullet there, substantial evidence, includes facts, reasonable assumptions predicated upon facts, and expert opinion supported by facts. There are certainly people that think when you prepare a CEQA document, you can just use your judgment. That is not the case. I mean, there are a few questions, I would say, out of those 70 plus questions where there's a tiny bit of subjectivity, but mostly it's entirely objective and it's based on facts. I have certainly worked on projects that, as a biologist, I didn't love them, but I didn't have a say to say one way or the other. We all had to stick to what was in the technical and scientific data. Let's see if there's anything else I wanted to say about this one. I think that's it for that. Well, let me mention that last bullet. In other words, those preparing CEQA documents and supporting technical studies are required to base their conclusions on substantial evidence and must show their work. So I wanted this bullet point in here because I think the show their work is a really important thing. Projects have been legally challenged because they drew a conclusion about a particular impact, and maybe they even attached some modeling data or something, but they did not explain how they got to that particular conclusion in a CEQA document. So nowadays people are much more careful about, you can't just, you have to show why you came to a certain conclusion about an impact. Okay, a few other points about CEQA. So CEQA documents, or CEQA does not judge whether a project is good or bad. They are not subjective opinion documents. And the second bullet point I think is really important, they belong to the lead agency. So even if a developer hires a consultant to prepare the CEQA document, that CEQA document still belongs to the lead agency, to the city. So what Calamasa does, and numerous cities also do now, is even if the developer prepares the CEQA document, and it's a good consultant. I mean, I would say most of the time, everybody I see out there is doing the same thing that I'm talking about, being objective. Nevertheless, because the document belongs to the city, the city then will hire third-party independent peer reviewers like myself. I mean, that's how I know Kelly is doing a ton of peer reviews for Calamasa. And we go through those documents with a fine-tooth comb and make sure that that developer's consultant covered all their bases, based all their conclusions on substantial evidence, technical data, facts. So, let's see. Projects, as you mentioned, Kelly named a lot of other agencies that have their hand in the CEQA process as well. Projects have to comply with a lot of other applicable local, state, and federal regulations. If it is a state permit that's being issued, such as, let's call it a 1600 stream bed alteration agreement permit, it's a really long name for that, for impacting drainages or jurisdictional waters, they too have to have a CEQA document on which to issue their permit. They're technically called responsible agencies. So if, for example, a developer in the city of Calamasa put out a CEQA document that was inadequate in the way that it addressed regulated waters, CDFW is not going to issue that permit. They're going to make the document, they're going to say the document has to be redone and recirculated to the public, or they're going to prepare their own CEQA document, which just adds more time on to the process. So not a good idea to cut corners. That's another one. All right. So a very important aspect of CEQA, and was, inherent on the first slide is to disclose environmental impacts to the public, right? So there are opportunities when these documents go out for public review that the public can comment on them, the public and agencies. So you'll see a lot of notices up there, but that's what it's called, the Notice of Intent to Adopt. So if the city, the M&D is done or the neg deck is done, it's ready to go out for public review. There's a particular noticing process. I won't go into total detail, but it affords the public a 30-day opportunity to comment on that document. Likewise, for an EIR, it also has public comment, but it's got 2 opportunities because you know how earlier I said it's a much more complicated, expensive, long process. There are 2 opportunities to comment. The first one is during the 30-day notice of preparation process. The EIR at that point isn't done, but what the city or a lead agency is asking the public to do is help us scope and define what this project should be. Tell us what your concerns are up front before we prepare that EIR. And then later, down the road, sometimes a year or more, the draft EIR is ready to go out for public review, taking into consideration the comments that were received during that NOP process, the first one, the 30-day. And then the draft EIR goes out on the streets for a 45-day public review. And, at that point, it probably should be longer. So I probably shouldn't even say that. It's going to get requests and have it be longer, but they're complicated, right? Just talked about that. So I wanted to, it's not on the slide, but I thought of this later, to the soliciting comments. So notices go out to, okay, so let me back up for a second. And this is more for the public. The city wants you to comment on these documents. They're required to solicit comments from you, the public, but the thing is they also want your input. They want to hear. They want to hear what the agencies have to say because, again, it protects them to hear what you have to say. You may know some things that they don't about a particular, project, particular area. Happens all the time with the tribes. Like they know there are some resources on the site that are confidential and the developer has no idea they're there. So it behooves everyone for the public agency to solicit comments from the public. So they will either, there are several ways, several methods of soliciting comments: posting on the site or around the site, posting a notice in the local newspaper, sending out hard copy notices to adjacent landowners. It also gets posted on the Office of Planning and Research, the State Clearinghouse. Goes out to responsible agencies, those who might have to issue a permit, goes to the county clerk, and to any other public entity or public member that has requested in writing. And it's in writing is the key there, to the city to receive any of the notices on any particular project. I don't know if I need to say this, but it's also a good idea to follow the city's website too. The city is really good at posting things on their website. So to follow that in case you didn't fall under one of those categories that I just mentioned. Whenever they send out those notices, there's usually a link, and this got better by all agencies across the state during COVID. Back in the day, we were printing these 500 or 600 page documents in hard copy, setting them at the planning desk, at the libraries. Now almost everything is electronic. So, but I don't, sometimes they're still at libraries, whatever, for those of us that, or those of you, I shouldn't say us, that don't have computers. Most everybody does now. All right. So last slide, providing meaningful comments. So I think this is an important one. I've had people ask me many times, again, the lead agencies want you to comment. I think some people from the public in different places are under the perception that nobody wants you to comment on a project as a member of the public, but they do. They want to hear from you. But there is a way to submit meaningful comments. If people simply say, I hate your project, that's probably not going to get you very far. For the CEQA process, commenters have to focus on the environmental aspects of the project. Always submit comments within the allocated public review period. Be concise. use neutral language. Let's see, relate the project's potential for impacts on the environment. It really helps to refer to specific sections in the document. Include evidence and facts to support your comments as well. And that is an important one. So people will say to me, if it took experts to prepare these CEQA documents, and it's all based on facts and science and technical evidence, how am I, Joe member of the public, supposed to be able to know how to comment on a CEQA document? One of the things that I teach my students and beginning entry, people in the business that I'm in, is I said you need to write these EIR sections and these MNDs, whatever, so that a high schooler can understand them. Maybe a smart senior or something like that, maybe not a freshman, but they're not supposed to be written to go over, the public's head. So I always, frown on that, try to take them down for more, to be more understandable. That doesn't mean there's not a lot of, 100 pages of air quality modeling data that's so boring. I have no idea what it means either when I look at it. But the point is to synthesize the information in summary form in the actual, air quality section itself, so that you can understand how they got from point A to point B in determining whether or not an impact was going to occur, and how that impact was going to be mitigated as well, down to less than significant. Let's see. And also, the last bullet provides suggestions how to make the proposed project a better project. Again, just saying, I hate the project doesn't help anyone. It needs to be, what could be better there? How could we make it better? Maybe it's reducing the footprint. Maybe it's reducing the density. I don't know. I don't have any examples for you right now, but it certainly helps if this is a collaborative, collective, respectful process when commenting on documents. So I think that's all.
Okay, and so we've talked a lot about different laws, different concepts that apply specifically to planning and land use. I also wanted to briefly touch on how public meetings are conducted, the rules that govern those meetings, because most major projects that will be considered by the city will come to one or both of your bodies, and they'll have to comply with these laws. And to build upon something that Wendy said, I know this panel is always cognizant that we are doing the people's business, right? And that the people have a voice here, they have a role in these discussions, and I want to lay out the framework for that participation. So you can see here that some of the key things I want to hone in on: how transparency is a core value for Calamasa. There's limits to discussion when we do hold public meetings, how the public participates, and how a meeting would be managed, right? And we want to make sure, again, transparency with efficiency, and that's the balance we are always trying to strike. So in the state constitution, there's this recognition that public scrutiny is a constitutional right, that the public generally has the ability to observe what's happening, to see public records, to attend public meetings, and so forth. The key law here is the Brown Act, and many of you attended my ethics training a week ago, so you know the answer to this one. It's not named after either of our governors, former governors. It is, in fact, a former state assemblyman, Ralph Brown, who's represented the Modesto area in the 50s and 60s. And in response to all these press reports of smoke-filled rooms and public business being conducted in private, the legislature passed a set of laws to ensure the public has a role at the table. And what does that mean? Basically that in general, we're going to make sure the people's business is conducted publicly. That's going to be the foundation of all these other requirements. And that our meetings will be open and public, except as otherwise provided. And those exceptions where the public isn't present are very narrow. really important restraint on the council, on planning commission, on the public, is that typically if it's not in the posted agenda for a meeting, it can't be discussed. You see, that's an absolute rule for special meetings. There's limited exceptions for regular meetings. But in general, we are going to proceed in accordance with the posted agenda. Here are some of those limited exceptions where, for a brief moment, we might touch on non-agenda items. You're responding to a public comment, questions for clarification, brief announcements, requests to place an item on a future agenda, things of that sort. What's important here is that these are limited exchanges that are typically unidirectional. We're not having a substantive debate or an exchange of ideas. We're requesting info, we're requesting an item for a future agenda, things of that sort. And so Monday, I have in front of me our newly adopted rules of procedure. The Brown Act empowers cities to adopt reasonable regulations for their meetings. Calamasa has long done so, and we recently updated, gave it a facelift on Monday. There are also similar regulations that apply to the Planning Commission, also updated on Monday. And the types of regulations in there are probably what you'd expect, right? Time limits, how a public hearing proceeds, what steps can be taken to maintain decorum, how public comments should be directed, things of that sort. Now, one thing that can cause confusion for officials, for the public, is what types of conduct may be unacceptable in a meeting. And obviously with the First Amendment and the Brown Act and these types of laws, there's an important role for the public to play. But where that role and that right is limited is when there's conduct that actually disrupts the proceedings. And there's new statutes that took effect in January of this year that clarify there are circumstances where a disruptive individual or group may be removed. Now, what's important is that there's a warning that's initially provided that this conduct is disruptive. It's not that I don't like it or it's too strident. It's disrupting the meeting, and if you continue, you may need to leave. You may be asked to leave. And what I recommend is typically erring on the side of letting people have their time. Under the regulations, typically each person will have 3 minutes to speak, and we try to hear what they have to say, and usually that is the best approach. But again, in egregious situations, we have to make sure the people's business can be conducted in an orderly manner. We don't want to provide anyone with a heckler's veto, with an ability to inhibit deliberation or staff presentations or other members of the public speaking. But the key thing again is actual disruption. And now our city manager discussing economic development.
Thank you, Brendan. So I want to touch on a few factors that may be considered, and this is not an all-inclusive list. These are just some major things that the City Council may consider when they're considering discretionary actions, especially those that are of a legislative nature. A big component of land use is economic development. It does shape how we produce revenue as a city. And revenue production for the city means our ability to provide more services to the community. That's how we do that. And the more that we can do to bring dollars from outside of the city, draw people in, the better off it is for the community. That's not to say that there aren't impacts from that, right? So if you look down in the Coachella Valley, for example, I list some revenue sources there that we focus usually on when we talk about economic development. I do have some separate slides for sales and property tax. We don't have a lot of TOT here, but you think of areas like, Disneyland in the Anaheim resort area, down in Coachella Valley, where you have a lot of different. It's a world class. It's a world draw. People from all over the world come and visit those things, and so their land use policy can be very much driven by their ability to bring in TOT. Other things that are considered that aren't direct impacts on revenue, but still are benefits to the community, are things that create jobs. But in all of these considerations, when we're looking at economic development, we're still subject to market forces. So, the free market will determine what types of businesses come. We can zone them in certain ways, but zoning is purposely broad to be able to attract a variety of different types of businesses. You're not going to zone something that says just a Costco can go here, and that's it. Because obviously Costco would know that, and they would know, okay, no one else can build there, therefore I have all the leverage here. And also it does limit your opportunities for alternative businesses to come in. So we look at sales tax. So when you go to the store and you pay sales tax for any good or any good, and services are not taxed, by the way, in California, only goods are. And of that 7.75% that you pay in Riverside County, if you make the purchase here in Calamasa, we get 1 percentage point of that 7.75%. I just want to point that out because I want people to understand when you pay sales tax, the city doesn't get all of that. A significant amount goes to the state. There's some distributions that the state does with that they're required to by state statute. You have the half-cent Measure A. So there's a basis of the base tax statewide is 7.25%, and it consists of the 1% what we call the Bradley Burns tax, which is what goes to the local jurisdiction, in our case the city, 6% to the state, and the 0.25% sales tax that goes to what's called the local transportation fund. And then we have a add-on measure that's countywide through Measure A for that is required to be used for transportation purposes. Now there are a lot of exceptions to even goods that are bought in the city. So when you go to a supermarket, any type of food products, if you get fruit or vegetables, things like that, those are not taxable. So that list has grown over the years in terms of the things that are exempt from tax. And I just want to point that out again so that people understand how revenue is generated at the city level. Now this is an interesting slide, and excuse me if it's hard to see, but in general, you see that green line on top. That is brick and mortar retail sales. That is the 1% local sales tax generated statewide. So in the year 2000, that number was just shy of $1 billion. So if you want to extrapolate that to what that means into actual sales, that means there were $100 billion, nearly $100 billion in taxable sales in that year. Conversely, in the year 2000, online sales were around $25–30 million. And as you can see, there's been significant growth in online sales, and we're all aware of that, right? I think everyone probably has at one time or another bought something online, and that has grown tremendously. And these are another one of those market forces that we're talking about. The retail environment has changed tremendously. We've seen comments that people love to go shopping in Redlands because they have these shops there. We don't have that same thing here. We are working towards that. We have zoning out there. We have approved projects that we're working to try to get high quality businesses that obviously are public desires, but also are good benefits for the city as well to be able to provide, again, sales tax revenue to provide services to the community. There's some laws that are pointed out in terms of how that has facilitated online growth, but demand has definitely shifted. You see, I would use a development like Victoria Gardens. Victoria Gardens was conceived, in the 80s and 90s and built in the early 2000s. That type of shopping center today would probably not be constructed the way it is because of the change in the market forces and the shift from brick and mortar retail to online retail. A lot of older malls, you're seeing them being converted into mixed use, a combination of housing and retail. So retail that would more support those local residents there. And also you're seeing a lot of conversion to lifestyle centers. So you see things with more experiences, things that can't be replicated online. Those are the kinds of things that you're seeing those shift towards as well. Again, when you have more services versus goods, that does eat into your sales tax revenue as well. So these are just some things that are considered when you are looking at these land use decisions and some of the things you have to envision. Because again, this is kind of a theme that no one land use decision or a decision on an application can be seen in a vacuum, right? Those decisions have impacts, both positive and negative, on the future. Briefly, I want to touch on property tax. So the general levy, if you look on your property tax bill, you see that first line, it is 1% of your assessed value. People that have resided in the same house for a very long time will note that that number is significantly lower than if your neighbor, let's say, just bought their house in the last year. Their property tax, even though they're right next to you, will be significantly higher. And again, this is how it breaks out, a typical breakdown of how our property tax dollar is distributed in Calamasa. So this doesn't count, I know there's newer developments with CFDs and everything like that that supplement either specific benefits in those communities or the impacts that development have to ensure that we're able to keep level of services up. But this is just the distribution of that 1%. Another consideration is infrastructure, and not just impacts on infrastructure, because we know that development does have impacts on infrastructure, but they are required to pay for their impacts in a variety of ways. First, development impact fees. Those are for various things. We have a library, park, transportation, police, fire facilities, and then we also have general government facilities as well. And then we also have two that are pretty unique to Riverside County. This is going to be a question for Wendy. Do other counties have, I know that Western Riverside County and Coachella Valley have mitigation fees related to MSHCP. What other counties have fees like that?
To try to get it set up so that it's streamlined once applications are then submitted or each time that they have a project. But Western Riverside County and Eastern Riverside County are relatively unique because, they're more than just a bio plan, they're a land use plan as well.
Right.
So, yeah. Anyway, good question, and I don't really know if there are others, but I know of a lot of other big regional HEBs. They're just handled differently.
And another one that we have is called the Transportation Uniform Mitigation Fee, or TUMF. That is a fee that is, again, paid both in Western Riverside County. There's a separate fee out in the Coachella Valley. That is actually mandated by Measure A. So I talked about that half-cent Measure A tax. So the whole purpose for Measure A was to pay for transportation projects. But it was in recognition of the fact that it isn't just existing users of transportation facilities that have an impact on transportation. It's also development as well. And so development pays in what we call the TUMF to mitigate their impacts and to allow for expansion of transportation infrastructure. I did want to point out that, or construction of facilities, construction of facilities, typically when it's like a subdivision, internal streets are required to be built, but other facilities may be necessary, but that actually end up benefiting the larger region. So I'll give you an example. When JP Ranch was built, there was a gap before that, there was a gap between Singleton and Bryant, and part of that development project was to connect those two segments. And as a result, not only does that allow for ingress-egress for JP Ranch, but it benefits the entire region. Now there's a continuous street from I-10 all the way up to Highway 38 that can then access the mountains. Development agreements, these are usually done as a result of legislative action that we talked about earlier, so for specific plans and of the nature of zoning changes of those kind of things. With that broad discretion, it actually gives the city better leverage to negotiate more facilities. And these are facilities that can, again, benefit more than just the project. So those are the opportunities that we have. In terms of our interchanges, we know that those are impacted. Each of those interchanges are at some stage of development. They're all in the planning stages, unfortunately, at this point. The one that's farthest along is the interim improvements which are actively being constructed at Cherry Valley Boulevard. And again, I want to emphasize those are interim. So those are not the only thing that's going to be done at Cherry Valley Boulevard. We are still in the environmental phase to construct the ultimate improvements at that interchange. Singleton ramp, Singleton, where the interim improvements, phase 1 improvements, if you will, of Singleton would add an eastbound off-ramp and a westbound on-ramp. That's being actively worked on as well. And then ultimately that interchange in the future will also be improved with additional capacity. Sandalwood, we've kicked off the process. There's 4 phases of process that we have to go through for Caltrans. We've recently engaged in the first phase of that process for Sandalwood. And the city of Calamasa is working on a deal with the city of Yucaipa to work on improvements for County Line Road interchange. Again, those are interim interchanges. There's a development in Yucaipa that's conditioned to provide interim improvements to support that project because the traffic would be coming into Calamasa. So we said to them, you need to mitigate that impact. And so they will be doing that by adding traffic lights and some improvements as an interim. That will not be the ultimate. There will also be improvements there as well. These things unfortunately take a significant amount of time. The Caltrans process is very lengthy. It's very complicated, and at times it's very frustrating. But ultimately, these are all being actively worked on. So I just wanted the public to know that. One thing that's not listed here is water infrastructure and availability. I know that's a big thing, and I hope I'm not stepping on Joe Zoba's toes over at Yucaipa Valley Water District. But I think that Oak Valley Town Center is a project that is entitled, and the retail portion will include a lake. And the first initial thought of people is like, well, we're in the middle of this drought, which actually was declared over recently. But we're in the middle of this drought. Why are we building this lake? The lake is actually a recharge facility. It is actually being used to enhance the Beaumont aquifer, which is the underlying aquifer of that location. And so they'll be able to use very clean and purified recycled water to then convert that into groundwater. And so that feature is not just a water waster, it actually contributes to our water resources in the region. And there's been a big investment in recycled water resources to support development. A lot of new development is now going as dual plumbed because a lot of water usage is done outside of the home. So recycled water availability in residential areas is critical to stretching our scarce water resources as much as possible. And this region has done a really good job of that. The Calamasa, the water basin that the northern part of Calamasa sits on is very healthy. It's actually risen. It's back to 1990 levels as far as the level of the water table, which is very good news. So groundwater management has been a very big topic statewide, and that is something that we have really been proactive in regionally. So when we talk about a drought statewide, it's not necessarily a one-size-fits-all type of deal. It really is something that can be significantly different region by region. For example, in San Bernardino, they have a water table that's so high that actually they have flooding impacts in basements. So again, it's not something that is just a blanket thing. New development can also have impacts and contribute to city services. It obviously, if we add streets, if we add people, it does impact our police and fire, and so we have to keep an eye on staffing. We have to keep an eye on facilities, and a lot of these developments, especially the major developments, have elements of them to address those impacts. Public works, as we add streets, there's more streets for us to maintain, more storm drains for us to maintain, streets, curbs, sidewalks, things of that nature. But on the flip side, it's about scalability. Right now, one thing that we are lacking, we have our senior center here, but we don't have a robust community services department, Parks and Recs program. We're not at a size to be able to support that yet, but as you grow, then you'll be able to administer those things. We're looking to partner with local agencies to help us along with that until we're able to self-sustain. but you have to have a certain amount of development for that to happen. So overall, again, project approval and consideration cannot be done in a vacuum, right? The city has goals. They want more parks. We want more police and fire. We want more services to be provided to us. And sometimes development is the way to pay for that. But that doesn't mean that there are that you can't discount the negative impacts that can come as well. Every land use or entitlement decision that is made always has pros and cons, positive and negative impacts. Even when you have a project that may appear to have no negatives, there could be, for example, we want to convert a parcel to open space. Well, open space there is a cost to maintain it, and it doesn't produce any revenue. But that might be an impact that is acceptable. On the flip side, there are uses that almost seem universally people that are against it, but it's something that could bring revenue to the city. So again, it's up to the individual policymakers that you are here today that have to weigh those pros and cons. And if you look at it from that perspective, it does show how difficult some of these decisions are. It's not just a very simple process. It's a very complicated process, even in your own mind as you're weighing your decisions. So I just want that to be recognized. So with that, that's the conclusion of our presentation. I do want to say that if you have questions, I know that one of the things we've talked about, Brendan touched upon public engagement during public meetings, and we have our public comment period during all of our meetings, right? And the council, the planning commission doesn't respond, and as Brendan alluded to, a lot of cases they can't respond. That doesn't mean they're not listening, but legally they cannot respond, especially if it's on a specific project, because that could have very big consequences if you do respond in public to those things. But if you have questions about specific things that are happening, Kelly and I are more than happy to sit down and meet with you and talk through with you the details of those things. That would be the more appropriate form to take. Our elected officials have to, they may be able to talk general policy with public, and I know they welcome that, but it's when you get down to specific projects, they may shy away, and they may even tell you, I cannot talk about that specific project, and I hope that we've demonstrated why that is. But that does not mean that staff can't answer those specific questions for you about those things, and we're more than willing to do that. So at this time, Mr. Chair, I would recommend that we take a 10-minute recess. This has been a lot of information. So
we have a 10-minute break. people will please take your seat, and I'm sure we got a little bit of the kibitz and gun, and I would like, if somebody has something to say, I would like them to fill out a comment sheet, one of these if they would. And I know, Woody, I have yours right here. You're top of the list. Thank you. And we're back in service, and I hope the public, well, even the planning commission, you know, you guys get to hear this quite often, but I'm sure you heard some things today you probably weren't aware of. You know, and it's I think you're always learning, and the rules are always changing. And Wendy gave us a very good commentary on it, and I thank you for it. You know, it's I've been on the planning commission, and I've heard this stuff over the last couple of years, and I still don't understand any of it, and I get very frustrated with it. But you know, we have to deal with it. So with that, I will open this back up and go to communications from the public. Mr. Woody.
Yes, ma'am. I have a loud voice. My name is William Wood. They call me Woody. I represent the water situation in our community of Sharondale. Underneath this project that's being built is the aquifer that feeds our community, feeds Rancho Calamasa community, and several other areas. We're talking 1,000 people. My question, I know you can't answer the question, but my question is, if this project in the beginning, in the end, whatever, contaminates that water system, who is responsible for paying for our water coming from Yucaipa or somebody else? Because we would have to abandon our wells. Rancho Calamasa would have to abandon their wells. The mayor would have to abandon his well. Yucaipa has a well coming out of the same aquifer right there on Singleton. Okay, and there's also a well further up is feeding, going across the street, across the freeway, my understanding. I personally have not seen the pipeline going over, but that's what I was told. The point being, I know the project, you know, the people that owns the property are entitled to build what they want to if they get the approval of you guys. But who is responsible for the water system if it gets contaminated? And who will be helping us? That's one project. Also, the traffic, I know that if you're talking about using Beckwith, which is the entrance to our community, to serve some of the other housing and stuff back there. It's not adequate for that. So, anyway, I will be quiet. Thank you for your time. And I've got to be in
No, Woody, before you sit down, you know, you talked to me a while back about the water.
Mm-hmm.
And I did get the answer, but I thought I knew the answer anyway.
Okay.
You know, and it's, you know, the containment basin behind Sharondale, that all that water that from the housing development
Correct.
goes into. Okay, that's there to catch the water
Mm-hmm.
and put it back into the ground.
Correct.
Okay,
Our water level
that's, see, times have changed. They didn't used to really do that substantially. Now any development has to contain water and put it in so it isn't transferred off to another location. And as far as contamination, you know, owners of the property are usually liable for anything.
Okay.
It's just, look at the dairies. They have to catch everything. They have to make sure that the water doesn't leave their property, and they have to maintain it. You know, it just, any city of LA, if you have steel, you have to contain the runoff from the rain on that steel and contain it on your property. And if there is any contamination, it has to be taken care of on site. So it's as far as I'm more concerned with contaminating water than I am on costs. You know, and that's I had property, or I have property in San Bernardino that I sold my water rights to it because of the plume that comes from the Air Force Base. You know, it contaminated, everything there is bad.
Mayor,
Yeah.
if I may? Thank you so much
Yes,
for
go
your
ahead.
question. Just like to add a little bit of additional information regarding the regulatory tools that are in place to protect groundwater supply. So first and foremost, the CEQA process and the staff level review of any project, and again, we're not talking about any particular development project today, we're talking very broadly about the process. So I'll just broadly say that development projects are required to meet strict water quality standards imposed by the state. There is an agency called the Regional Water Quality Control Board that all projects must be designed to their water quality standards. In the event, in the unlikely event that a development project were to have negative impacts related to the groundwater basin, the Regional Water Quality Control Board is in place to help with any potential contaminants that may occur. That's unlikely and not anticipated with any of our development projects, but there are agencies in place to protect those sorts of resources.
Thank you, Kelly.
Thank you.
Thank
Okay.
you, sir. Thank you, Mayor.
You're
Thank you,
welcome.
ma'am. Anything else? Okay.
Mr. Wright.
Okay, I'm going to try to be somewhat diplomatic here, but I want to make sure that the point gets across. And everybody got a handout, and what I put in that handout, I stand by. There needs to be more transparency, and there needs to be a better forum to engage in confrontation so there can be some resolution. You cannot resolve it if you don't try or make an attempt to do anything about it. Kelly, I don't want to step on your toes here, but I've got a question. The General Plan Advisory Committee, it states that the General Plan Advisory Committee was a group established for the purposes of providing input and guidance to update the general plan. The GPAC has been an integral part of the general plan updating process by conducting community outreach, providing insight, direction on the issues facing Calimesa, assisting in the city in defining direction of the general plan, planning effort. The GPAC continued to meet throughout the general plan update process, providing direction on goals and reviewing proposed policies. Who are these people on this committee? And did they have any input in any of the previous approvals of the previous warehouses that came before the city? And why wasn't it, and I'm not trying to step on your toes, it's something that needs to be addressed because they're advising.
It's a great question. Were you?
And the other
would you
thing
like
real
me to
quick
respond? Go ahead.
is I need a copy of the February 26, 2013 EIR.
Okay.
Take it, Kelly.
Well, thank you, James. That's a great question. You're not stepping on any toes. I'm happy to answer that. So the General Plan Advisory Committee was a subcommittee of various stakeholders that was in effect during the time of our last comprehensive general plan update. The general plan was last comprehensively updated in 2014, and it's my understanding that the GPAC was dissolved thereafter. So the purpose of it was, while every element of the general plan was being updated, that there was this stakeholder body that would provide input. I think we may have some members of the GPAC. Mike, so is it your recollection that the GPAC dissolved after the general plan was adopted? Correct. Okay, so there's the answer to that. It's not currently a standing body today because we're not going through a comprehensive general plan update. Your second question, I can certainly get you a copy of the 2013 EIR for the general plan.
Right, and I'm not trying to step on toes. I'm protecting the people I'm advocating for, and I want there to be a better exchange and reconciling the differences that are obviously around. And I respect you 100%, and I appreciate you and your boss for
Likewise.
your help and ability to explain things. I just want to be able to trust you people, because there are people out there who are elderly, who are sensitive receptors, who do not trust you. They think you're going to sell them out to the developers and disregard them, abandon them, get rid of the Rancho Calamasa and Sharondale mobile home parks and put in mega warehouses.
Thank you, Mr.
You might as
Wright.
well put that on the city seal if that's the case.
Thank you.
And James, just to reiterate a comment that was made during the presentation, the Planning Commission and the Council in these Brown Act meetings that were, similar to the one that we're conducting here today, there are constraints on what can be discussed because it depends on what's on the agenda, what's been on the circulated agenda. However, staff members don't have the same restrictions. So just as you and I have many, many times corresponded and had lots of discussions about items that are not within the context of a Brown Act meeting, I would encourage you and any other member of the public that would like more detailed information related to any development project to please meet with staff. We have much more ability to answer detailed questions.
And can I just add on to that too? I think that there's also, I know there's questions usually about specific projects as well. I think that there's a difference between, Brendan kind of pointed this out, is a general discussion of a certain type versus a specific project. And I think that we're certainly not able to discuss a certain project if it's an active application, because that would not be appropriate until it comes to that per specific time. But there's a little more flexibility in other circumstances when it's talking about something more in general. That helps.
Okay, willing to work with you. Please respect your city residents and respect them.
Thank you, James.
Thank you. Ms. Delaney?
I just have a couple of questions about the 300-foot notification rule, and this is for like the scoping meeting and the notice of preparation and those different notifications. I think it's 300 feet from the project site. I was just wondering if that's CEQA guidelines or is that our municipal code?
Thank you today. That's our municipal code. You can find that in our hearings and appeals section of our municipal code.
Okay, thank you. And then for public comments at a public hearing for any, project that's under consideration, each member has on the item, 3 minutes to comment, or they could email in comments. I know that's allowed as well. So that's members of the public. And then is the developer, he's considered the applicant, or is he also a stakeholder like the public? I don't know how that works with the Brown Act, the meetings, yeah.
I'll just start by saying he or she, and then I'll let our...
Yeah, there you go. There are lots of these.
Or they or it, if it's a corporate
Okay,
entity.
well-
But anyway, the point that you wanted to make, right, about different time allocations, a couple clarifications.
Yeah,
The
thank you.
first one is under our newly adopted resolution. There's a default of 3 minutes per speaker from the public, but the presiding officer, which would be the chair or mayor usually, has discretion to modify that amount depending on the amount of people there. Right.
Okay.
So it's not 3 minutes is hard and
For
fast.
sure, right.
So members of the public get their time under the Brown Act and under these concepts of due process. Were you here for the presentation earlier?
Mhm.
Okay, so you saw the slide, right? Everyone's entitled to that. An ability to participate. It's been recognized that an applicant who owns property has a distinct property interest and, a different type of role to play in the proceeding. So jurisdictions across the state will typically allocate additional time to an applicant that is greater than a member of the public to ensure that that property owner who has a distinct interest here in their own property has the ability to fully articulate the proposal.
Okay.
So the public has a very compelling due process right, as does the applicant, and the courts and the law have recognized they're somewhat distinct, and that results in slightly different time periods allocated to each.
Okay, thank you.
And I think I'll add to that too. I think that, you know, so a lot of times there's typically not limits put on the number of speakers too, right? So
Right.
even though there might be only 3 minutes, but you may have, you know, if 100 people to show up to speak, collectively the public actually may have more collective input than the applicant. So
Right.
there's that dynamic too, is that there's not a really limit on the number of speakers necessarily versus the applicant. So that does play into the dynamic
And
too.
that's what I tell
Yeah,
them.
yeah.
Yeah, come to the meeting and speak. Then about, so if there's a project and there are substantial impacts that cannot be mitigated, I'm wondering, because it might happen that there needs to be a statement of overriding concerns that gets adopted by city council. So if you can generally say what are some types of overriding concerns, and this may not be something you can answer.
Thank you, Danae. That is something I can answer. I can say a lot of times statements of overriding considerations, as they're called under CEQA, will focus on things like the city's desire to provide jobs, housing, and economic development. So there may be a CEQA document out there that says there are significant unavoidable impacts related to traffic or biology or some other resource area. But the important thing is, as Wendy stated in her slides, a CEQA document it's an objective document that doesn't say if a project's good or bad. It's simply for disclosure, and then when the document is presented to decision makers, it's up to the decision makers to look at all of the information, including potential environmental impacts, including any potential positive things such as jobs, housing, etc. And so those are some resource areas, or some, I should say, some areas that a statement of override might focus on.
Okay.
Do you have anything else to say about that, Wendy?
No, the statement of overriding considerations used to be a paragraph, but now, because of all the things I mentioned earlier and people getting more strict in their interpretation of CEQA, those have ended up being written more often by attorneys, so that it's absolutely, this lead agency is absolutely covered if they're going to override override a project's environmental impacts and approve that project. So.
Okay, thank you.
Okay, and then one last question. This is not for a specific project, but it's for a specific type of project that could be considered in the city. So, and it was kind of under the heading of land use decisions. So for certain types of projects that might have online sales, and they might be distributing those online sales. And I'm just wondering, is it possible if we approve these types of projects, you guys know what I'm talking about, probably, can we make it a condition that it's a point of sale project? Does that make sense?
Yes, no, I'm picking up what you're throwing down. So yeah, I don't know if we could get that specific on those things. I know that's a big point of contention. I did have some notes in here that I didn't bring up, but I know there's a neighbor to our south that has one of these facilities that you're referring to. And if you look at where their sales tax has gone over the last couple of years, they were at 7 million and change in about 7.5 million in 2020, and now their sales tax revenues over $29 million. So that's a significant increase.
For point of sale.
For point of sale, correct. Well, overall, that's their overall, but a lot of that's attributed to point of sale. And then your point of sale is how it determines how much of the county pool you get, because not all online sales go to the point of sale. Some of them go to the county pool depending on where they're cited from. So if it's shipped from out of state, for example, it would come out, it would go to the county pool and then distributed based on your share of your local point of sale relative to the county. So usually the way that works to try to get those type of usage into your city, it's more done through economic development incentives. And our tools are fewer and fewer in the state to be able to accomplish that. I will say there has been some talk among cities in the League of California Cities of trying to sponsor legislation that would change how those sales where those sales tax dollars are distributed. Having a recognition that where the distribution center is located obviously does have some impacts, so you have to keep some of the revenue there. But also there's impacts to local. So like if all of us are buying on Amazon, we always see the Amazon vans driving everywhere. That's an impact on us, but we're not necessarily getting those sales if they're being shipped from somewhere in California, right? So it's a complicated issue, and I know that there's a lot of back and forth on that. So even if you were to get a fulfillment center that would be sited in the city where the sales tax would come to, there is a possibility in the future that distribution could change. So that's something to keep in mind. Again, it's one of those, one of those data points in out of many that are made when you have these decisions. But you can certainly work on economic development programs that can attract those type of usages and maybe favor those through those means rather than through conditional use.
Yeah, and if I could use an example, just so that you can kind of understand what my mind is thinking. So you mentioned Amazon, and I buy Amazon. I have the trucks go by my house too. So if the point of sale was like an office with a computer system taking in all of the orders in, say, Simi Valley, and then we're just the distribution, do we get any tax revenue from that?
No, and usually when it comes to those type of sales, it's where the goods being shipped from. So it doesn't matter where the computer is located that's taking the order. In this case, it has to do with where. So if it's a warehouse in one of the big places for this is in the Central Valley in Shafter. They have some very big distribution centers there that are not Amazon. They're actually other types of online usage. And but if it's shipped from there and it's shipped to somewhere in California, they will get the sales tax for that. If it's shipped from a warehouse in Las Vegas, because I know there's big Amazon warehouses in Las Vegas. If it's shipped from there, then that sales tax would go to the pool, and we get a portion of that based on our share of our local point of sale.
Okay.
Well,
Yeah.
Thank you.
Yeah.
I'd like to add on just a few comments to that. Typically, we've talked a lot about land use and entitlement and the steps and processes that need to occur. Something I'll say specific about the land use that's being discussed here is that, in my experience, almost always what the city is being asked to approve is what's called a speculative facility. And so there are the folks that are proposing it may have an idea of the types of users that might come in and utilize a facility, but really what we are analyzing under CEQA and what we are asking Planning Commission or Council to approve, the end user is not known yet. So what they do is they get it's called a shell. The shell of the building is approved, and a broad land use category is analyzed under CEQA. And then once, in theory, if the project is approved, then they would go and take that out to the free market and try to get a tenant. And so typically the tenants are found after entitlement approval is granted. So just to add on to Ms. Delaney's question, we may not quite have that opportunity because these are speculative facilities being requested.
Okay, thank you.
Thank you.
Ron Roy?
Okay, council. First thing I wanted to say is what my guiding thought today is that the city has a police power over land use. You never talk about the police power. After 5 years of these warehouses, and then under that police power, their number one goal is to promote the general welfare of its residents.
And so you have to keep that in mind. I still think a lot of the frustration is people don't think that they're the employer and you're the employee. They still don't get that. Now, the next point I wanted to bring up is on the general plan that was developed over time, and it's a living document. You have to renew it every 10 years, and you can amend it on an annual basis. Every resident should know that. Okay, part of your ordinance development is you came up with an ordinance that would cap warehouse sizes to 250,000 square feet. And that, my understanding is that would be a legislative item. It was legislative. Okay, so that should be in keeping with the overriding principle of the general plan for the quality of life of the people. Now, specific plans, I think some people might think that's a tactic to create, to circumvent that cap. And then they, and these are, not only are specific plans created, but amendments to specific plans are created. So I think that's wrong to do that they should have stuck with the 250,000 cap. Okay, so the other point is on the revenue sources, some really good points here about the revenue sources. And I think a lot of people are going to think it's not determined. Nobody really knows. They promised you sales tax revenue, but they're speculative, as the person correctly pointed out. So you don't even know what kind of money you're going to get when you approve these, things that take hundreds of acres that you never get back. So, it's something really wrong with this picture. So there are other, you talk about diversity of land use. Well, in the Inland Empire now, you all got to be going down the 10 every once in a while. And so you're seeing that there's no longer diversity of land use. It's becoming monolithic to the point where communities are becoming warehouse towns. So I sometimes concerned that you're not really fully disclosing that there's more than one revenue source besides a to-be-determined warehouse allocation from the state or a county. Whether it's going to be a point of sale or maybe a refrigeration warehouse, will there be no sales tax generated? So the point then is, what are the other uses we should look at? And look at the residential communities that we have. You get developer fees. Your sources are long-term and kind of on temporary. So your developer fees build out the infrastructure on site, and they also generate revenue. And then you have facility fees, if the gentleman would like to elaborate. Your community facility districts have hundreds of millions of dollars. So you have another very lucrative revenue source from Melrose fees, developer fees from those residential projects, which Summerwind will give you. You also have future facility fees, which are taxed that you can, as a city council, increase or decrease over time. So look at other uses of revenue. And again, it's all about the general welfare of the community. They want a quality of life. This decision on the warehouse is a complete disaster. And it is. You have to take responsibility for the disastrous decision you made. And it's an epically bad decision. It's going to scar the community for generations to come. You got to think about your grandkids and your great-grandkids. So you got to just nip this in the bud. We're not Unix either. And I appreciate that you are not Unix, but we're not Unix either. So we have a right to say, find a way, be creative, use the police power over land use to protect the general welfare, and think about one thing, the people in this community. And what you do is use your whatever resources, you did in education or...
Could you please wrap it up, Mr. Roy?
Yes, sir. I'm done, and I appreciate it.
Okay, thank you very much.
Thank you for doing that.
Linda, is it Bearden?
Bearden, yes. Bear, again.
Well, the B, I didn't know if that was a B or an R.
Yeah. Maiden name Barden.
Yeah.
Get it? Okay. Anyway, this is lovely. I mean, very informative. Thank you for putting this all together. Much of it's over my pay grade, but it's nice. I've been a resident of Calamasa for over 30 years. I moved here because of this little logo that is there, that is on every little, that logo, because of that, because of the community that this is, or was. And I'm very grateful that we have missed a lot of progress, but I see it's knocking at the door right now with, you know, all this that's happening. So one thing I can just say that I've heard by the 76 station, that land, they're looking at a warehouse over there. Don't know for sure, but that's what I've heard. Jack in the Box, there's going to be something down there. Mesa Verde, out here. Summer Wind, out there. And then what else is going on with the warehouses and all that. This will no longer be an effective logo. It will not be the right logo for Calamasa anymore with all that. Now you drive through Calamasa and what do you see? I mean, you see open spaces. I don't know how many of you hike, but over at Mesa Verde area, miles and miles. My husband's an ultra runner, and he's ran miles over there. You know, when you read, and this is, I'm probably outdated on this, but, you know, the mission to preserve and enhance the open space, atmosphere, and quality of life in Calamasa. That's the mission. So when people talk about the warehouse, it's like, what? I mean, seriously? I mean, that's to me, I can't even believe that's being discussed, but evidently it's a hot topic, and yeah. But the vision, the city of Calamasa is dedicated to remaining a community that honors its beautiful natural settings through open space preservation, wildlife corridors, and extensive trail systems. Where? Extensive trail systems? They're over there. My husband's taken built a bench, and we call it the Peaks Trail to get over to his bench that's above Summer Wind area and over a hill over there. I could take anybody there if you'd like. It's gorgeous. Sit on the bench and you can look at Mount Baldy, San Jacinto, San Bernardino Peak. It's gorgeous. So I just, again, I don't know how Calamasa is going to have to, I don't know. So I don't really have I just have a comment. So how's that?
If
Anybody want to clap or anything? Well, we can't clap? Oh. Thank you. Anyway, let's try not to do all of this stuff.
Sure. Mrs.
Okay.
Mrs. Bearden, I think you. Bearden?
Yes.
Thank you. I appreciate your comments. I do clap for your comments, and I spend a lot of time thinking about your comments. So I'm, as you know, I'm the planning director for the city, and so what I have to do in any given day, it does have quite a bit to do with land use development. I have my nose in a CEQA document or a development application every day of the week. But in my earlier comments, what I tried to convey, and maybe I'll just touch on that again, is that it's not the only thing that we do in the city. So the mission and the community values that you just eloquently read from, they stand true. They stand true even with development that's coming our way. Development within our city and trails and open space are not two mutually exclusive concepts. They can and they do and they will continue to coexist. So when you talk about the extensive trail system out in Mesa Verde and Summerwind, very happy to report that many of those trails are going to stay or be enhanced as development occurs. We have a master plan of trails that Councilmember Cervantes and I like to talk about on a very frequent basis. How can we get these trail systems that have been planned for so many years actually constructed? I spend probably more time than I want to in discussion with the Regional Conservation Authority, the wildlife agencies, and various conservation agencies in support of the statements that you're making today. So while one piece of what the city does is to implement our development plans for the future, all of our mission statement, all of our focus on trails and open space, it continues to exist. And I guess I'll just say in this forum that we promise that we are implementing those goals on a daily basis.
Well, in the like I said, over 30 years that I've lived here, I don't know what trails have been, I mean, we've found trails. I mean, if anybody's ever been over to on Singleton,
up there where the, it used to be, I guess it's a old
Stagecoach.
road up in there. If you've ever been up there, my husband's also got a bench up there that you can go in and sit. He's quite handy, and he makes trails too, if anybody wants to know.
Tell
Matter of
your
fact, he took
husband
your
that he
class,
might
my
be,
husband,
he might
long
be
time ago.
trespassing.
Part of that.
So, anyway, but yeah,
Okay.
I just don't know where, you know, I mean, it's a beautiful community, and it just needs to,
I would be more than happy to sit with you at any time that you may have available and to go over the city's master plan of trails.
Oh.
Also talk about some of the open space areas that are conserved in perpetuity and make sure that you feel good about how we're supporting the city's mission.
great, okay, I'm retired, we'll have a meeting.
Thank you.
No.
Oh, I'm so sorry.
No.
I told her yes.
Who told her yeah?
I did. I'm so sorry.
Is this your show?
No. Sorry. Go ahead.
Thank you. We'll move on to council members and planning commissioners' comments. You guys got anything you want to add?
Yeah, I'll just, I just had a couple questions, just like to direct towards staff. So, it's kind of a two-part question. Briefly kind of mentioned as far as, findings. So when a, application it makes its all the way, its way to either the planning commission or the city council, and we're actually going to get to the point where we're actually going to make a decision on that specific project. So first part of the question is when it's like this, the quasi-judicial type situation, and we have to cite findings and provide evidence. Would you kind of be able to expand on that for everybody as far as what type of that means by findings and what we have to actually provide when we're trying to remain impartial?
I'd be happy to. And so a lot of this action will happen at the planning commission level, and you will see it more typically for appeals of a decision the planning commission makes. There will be circumstances where council will sit as the quasi-judicial deciding body, right? But decisions concerning discretionary permits will typically be memorialized in a resolution. The resolution will cite all these facts about the project, the sequencing and whatnot, but the heart of that resolution is listing out the set of findings, right? What's required will be laid out in the municipal code, right? And staff will propose findings for council or planning commission's consideration. Sometimes what happens is that planning commission or council accepts the proposed findings submitted by staff, right? Let's say it's, okay, neighborhood compatibility. And then it'll specify this proposed Starbucks is compatible with the adjacent block because there's other restaurants and commercial activities, something like that. We would have content, we'd have reasoning that would tie the specifics of this proposal to the required finding. Sometimes what happens is council or planning commission may have additional thoughts. Okay, these are proposed findings, we actually want to add to it with this additional consideration or that consideration. Sometimes council or planning commission may not agree with the staff proposal, and they can direct staff, no, we don't agree, come back, we're going to deny this project. Or you recommend denial, we want it to be approved. Come back, here are the types of findings we believe supports the decision we've made. And then at the subsequent meeting, that resolution, as directed by council, will be then reconsidered and potentially approved. But I can provide you with some examples, which I think would be helpful, of recent approvals that have detailed findings.
And then just kind of add on that, when it's not a situation where you have to provide those findings where you have that, where you said almost full discretion, would you be able to kind of elaborate on that, where it's, if it's going to be like a zone change or something where those findings aren't going to be required to that extent?
Yes. So let's say we want to update one of our general plan maps to change the designation from, open space, or we were going to change it from something else to open space or whatever. We wouldn't have to go through the same exercise of these expansive findings that we just talked about, right? There may be certain requirements planning commission would recommend for your consideration this act, or not recommended, or what have you. But then you would have, in most instances, wide discretion, and your decision would not have to be tied in the same way to specific enumerated findings, right? There are things you'd have to think about, and staff would make sure it's consistent with the existing general plan, right? If it's a specific plan, it's consistent with the general plan. If it's zoning, it's consistent with the general plan, things like that, right? But you don't have to tie it to enumerated findings in the way you'd have to for something like a CUP.
All right, thank you. I think that's all I had. Thank you.
Okay, I think this is for Will. We get a lot of, as a council member, I get people coming to us, and like you said, when are we going to get a Trader Joe's? Are we going to get a Target? I wanted to let the public know, how do we go about courting these people that own Trader Joe's, or getting somebody in there, a Trader Joe's or a Target or whatever? What does that process look like?
So we do a number of things. Currently, this is going to change, and I'm going to be probably more focusing on myself. But we have had an economic development consultant that helps us reach out to those. A lot of times, what we'll do is we will work with the landowners themselves too. So especially when you're looking at a large retail center. So let's take Oak Valley Town Center for example. You know, there is this thing that once a project is entitled, sometimes our work doesn't stop there. And I think in the economic development case, that is absolutely the case. Is that we will try to work with the developer to bring in quality tenants because it helps everyone. And obviously it helps them, but it helps the city as well. And so I think it's important that we work with them and we're in communication. Next month, we're not going this time around, but it's something that I'm interested in the future. There's the International Shopping Center conference that happens in Las Vegas, and the only reason really it happens in Las Vegas is because they have the convention space to host it. A lot of cities go there; they have booths, so they try to sell themselves and help coordinate those things. They schedule a lot of meetings with various businesses to try to come to their cities. So there's different things that we can do, in outreach to reach these. And so a lot of times it's working with the landowner and also just trying to contact them directly. We want to try to put Calamasa on the map, so to speak, when it comes to those kind of things. And our outreach efforts will get us there. Yeah.
Okay. Thank you.
First a comment and then a question. First, thank you to all of you. I can tell a lot of thought and effort went into your presentations. Very informative, educational. I felt like I was in a classroom setting, and I learned a lot. So thank you. I have a question for our CEQA consultant. So thank you for condensing 1,000 PowerPoint slides and a semester's worth of material into 10 slides. And so, I'm still very much learning about this process, and there's a lot of moving parts to it. So if my question reveals some ignorance, it's not your fault, it's my own. So when the EIR, this question is in regard to an EIR, provides information about environmental impacts of a project, and it also provides possible mitigations, right, or alternatives and so forth. I'm assuming that that the community of experts and research are the ones who come together to identify not only what the impacts are, but also what the sufficient or potentially sufficient mitigation efforts would be.
They do.
Right?
Yeah.
And so do they also ultimately decide, or is there any sort of, at the conclusion of the matter, decide whether or not the project has sufficiently done their due diligence in mitigating those environmental impacts, do they make a determination on that, or
Yes.
do they leave it up to the cities and
Yeah.
other agencies to decide that?
They include that in the document. So
Okay.
there's the step process in each of the questions, or the sections, whether biology, cultural, water quality, whatever. And it starts with what is out there on the site right now.
Right.
What's the traffic if the site's not developed? What's the traffic if the site is going to be developed? So you go through this whole process, starting with baseline, it's called, and you talk about what the project is going to do to all of these various categories. Okay? And then you say, based on that, based on thresholds that I was talking about earlier, I don't know if I explained that well, but you determine if the project has no impact, less than significant impact, less than significant with mitigation, or potentially significant. And then the next thing is you have to address those impacts if you do have some. So you say, you explain mitigation, like we come up with all kinds of mitigation, and it's not easy, and it's very expensive, very often. And then you have another conclusion, which hopefully you can always say less than significant with mitigation. But there are times you struggle. Air quality is one, because especially when you're going to grade a site, mass grade a site, you're going to stir up a lot of dust. But that's temporary. So a lot of times the impacts that can't be mitigated to less than significant are temporary, which is a good thing, right? It's more the permanent ones.
Right.
Like diesel trucks or whatever. So you may, I worked on a warehouse project where all the diesel trucks have to be a certain tier, a certain kind of energy, a certain kind of technology to bring those impacts to less than significant. Again, really expensive, but sometimes the payoff is better.
Right. So, also for the benefit of the public and all of us, when we do finally get an EIR and we get a list of those mitigations, and then ultimately CEQA maybe says that those have been sufficiently mitigated, the public can then therefore trust the outcome of that report, right? Could they put in I guess I'm asking for your opinion maybe on this. Would you say that the public could put their full confidence in not only the report, but also that the environmental impacts have been mitigated, and then they can have confidence in that? Because a lot of times we hear that they still don't trust the outcome of those reports, or sometimes they didn't consider certain things that they should have, or they relied on faulty information. So maybe you can speak to a little bit of that.
And that's the point of public review.
Right.
And peer reviews, whatever. So everything goes into the draft EIR. They're not bulletproof. It isn't like somebody can't miss something.
Sure.
Which is why a lead agency should either be responsible for them being prepared themselves or have them peer reviewed. It depends.
Absolutely.
Peer review is a whole nother layer that a developer has to pay for, but it makes the lead agency feel better, makes the public feel better, that there's an objective third party that has reviewed these things. So, there are a ton of tech studies and things to review, but then after all of that, it still goes out to the public to review and see what they think. And then after all of that, is talking about, meaningful comments. Don't just say you hate the project, say something about the environmental. However, when it comes to the decision makers, even if there are comments in there that just say I hate the project, they're not really environmental, I might not have to respond to those comments as the CEQA consultant, but they're all still going to be on paper for you to see, even if they're not necessarily. So we also, even after all that's said and done and people have reviewed it, we have to respond to the comments. So somebody might say, I don't like how you modeled the air quality or the greenhouse gas emissions or whatever. We have to respond to that if it's an environmental comment.
Right.
And say, well, we did do it right. That's just your opinion. But, you can have two different expert opinions, but both should be based on fact. It's rare that you have to do that, but, a lot of people also comment on documents. Not saying names or organizations, but some people comment on the environmental aspects of an EIR, and they don't care about the environmental aspects of the EIR at all. They're out for a different reason. So.
Yeah, no, thank you so much. I was very interested in seeing how much research and data and review and analysis and expert study goes into developing that. And so it seemed to me that it's a very well compiled and researched document that we could put some confidence behind as
Councilmember,
public.
if I may, I'd like
Yeah.
to add just a thought to that as well. So a lot of what happens in the CEQA analysis process occurs prior to a public hearing, but it by no means ends at project approval, and I think that's a really important point to make. So a component of every EIR is going to be the Mitigation Monitoring and Reporting Program, MMRP. We've talked about that in various settings for various projects. And that's a document that lives with the project. So there's various project milestones. You know, prior to grading, you have to do this. Maybe you need to have archaeological monitoring or tribal monitoring during grading. Before you can impact stream beds, you need to get, you know, permits from U.S. Fish and Wildlife. Prior to building permit, you need to do this, whatever it may be. For air quality purposes, there may be limits on paint coatings and things like that. Traffic improvements, that lives for the life of the project, and I guess I bring that up to say, by no means do we do an analysis and then close the book after the public hearing and say, good luck, I hope you do all that. We're checking their work every step of the way to make sure that all of the mitigation measures are complied with.
That is a great ad.
Yeah.
I should have said that.
Very helpful.
Anybody on the planning side? Could you turn your mic on?
Is said and done, as far as the monitoring and reporting, who monitors the mitigation after it's done?
Me.
And like the accountability, so you.
Yeah, so it's part of my function as the planning director is that I hold the development community accountable to not only mitigation measures but also to conditions of approval. So I talked a moment ago about different project milestones, and you know, the development community will come to us and say, hey, I'd really like a grading permit, I'd really like a building permit, I'd really like a certificate of occupancy, I'd really like a business license. Those are kind of the big ticket milestones for a project, and every step of the way, we need to make sure that they're meeting conditions of approval and mitigation measures, and that's a function of the planning department. It's the city.
The city is the lead agency. It's still responsible for that. But there are like South Coast Air Quality Management District. You know, if they issue a permit on a project, they do check. I've had them come out to project sites and check it, you know, during construction and again after operation. So it's kind of, yeah. There's more eyes upon projects generally than just the lead agency as well.
And I will say it's not necessarily just city staff either. It's you know, city staff facilitates it. So if it's some kind of monitoring for air quality or type of trucks or something like that, we may need to farm that out. And that is also something that is paid on deposit by the project owner, the developer. It's not a cost that comes out of the city's pocket. It is something that is paid for by them. So obviously we don't want to make sure it doesn't impact our general fund or anything like that too.
Anyone else? Go ahead,
Thank you.
Steve.
I just want to make a comment as far as on the planning commission. We'd more than love to have you people show up. I've been on the commission now a dozen years now. I don't think we've ever seen more than 10 people at any particular meeting. We're here, we're volunteers. I take time out of my family's life to be here to do my job for you guys. Please come to the meeting. And like I always tell people, look at the zoning map and see what that empty field is. Because I'm sorry, I don't believe the city of Calamasa owns any open space. It's all private property. So for the gal who his husband goes running, just be very careful because he's on private property. So you have to remember that. There is other people. But getting to the planning commission, just one thing I want to let you know. When Mesa Verde was approved this last time, which my understanding originally started back in the mid-'80s with a golf course, Well, this last time, we ended up getting 1/3 of the acreage left as open space. We busted their butts to have the trail system in there, to have it where we could actually bring our horse trailers in and unload our horses for riding. We knocked it out of the park. Unfortunately, they couldn't handle the business and went belly up and it sold. So we shall see what comes back and around us. But we do everything we can to do this. We all live here in this city. We're not going to let it go away, but you also got to remember, you got to look at that map, and that kind of dictates what kind of development is coming. And so when you look across that field in front of Sharondale, and you have that massive expanse, my first thought was that'd be a great place for a park. Well, now everybody is so micro-conservative with their dirty, smoggy air, even though California regulates the crud out of everything. You can't put a park there next to the freeway. God forbid you put those kids in that harmful space. So there's all kinds of things we have to look at. That is why I think we more or less send with commercial along the freeways, and why we see commercial along the freeways, because nobody wants to live along the freeways. We're all removed. But I just want to say, once again, we do look at the project. We look at what comes before us. When I have people stop me in the market, ask me, oh God, how many years ago Nike was coming to town? Remember all that, people? Nike was coming to town. Nike were... When I see something come in front of me, I give it my full attention, but I am not going on hearsay or anything else. And so when people come up and say, you can't do this, just remind you, when it comes in, look in front of the paper, look on the city website, show up to our meetings. Please feel free to express yourself. We'd love to have you come. But be aware, we're not here to shut you out or anything like that. We're just here to do our job and improve our city. And yes, that is our opinion, what we're doing on. We listen to neighbors and everything else, but it is subjective, because I have my opinion on things just like you have your opinion on things. So we just learn, listen, live, but we do look out for the city. And I just wanted to put that out. Thank you.
Can I just piggyback off to one of those things that you did mention, and this is something that I wanted to have addressed. Brendan, when we talk about legislative action and the broad authority that we have, that the City Council and the Planning Commission have, but if we were to take action to do a zone change on a certain piece of land, just through our own action and not through an application, if we wanted to say we declare that this land is now zoned open space, what would happen?
Well, it depends. No. I think that, one big thing is, why we had that separate section on housing, right? So it's that would be the initial question. Okay, is it going to reduce current housing? Is it a space currently zoned for housing? Things of that sort. That is a significant constraint even in legislative acts, right? But I kind of look at that as its own carve-out. So let's say it's not residential, right? It's not housing right now. It's another type of use, and we want to rezone to open space, right? The next question might be, who's there now, right? How does that applicant feel about it? Because let's say it's an existing commercial enterprise, it would become a legal non-conforming use. That's going to have certain long-term ramifications for the city, for its tax base and so forth. Those would be all the sorts of considerations that the city would have to make. And that's just some initial takes. I'm sure there's additional considerations you would have from a finance and city management perspective.
I'm just looking at it from more of the standpoint, if it's privately owned, privately owned land, and you wanted to just make it open space. You talked about legal non-conforming, so that means that the zoning that they bought it as would still apply, basically.
Yeah, when you have property, you have a certain right to recoup your investment, your use of the property. So if the city opts to rezone to your property, you would have a set amount of time typically to recoup that amount, or you would receive a large amount from the city as a takings type payment. It wouldn't be instant without any consequence for the city. The city would have to pay up, or the city would have to wait, things of that sort. But again, we're speaking generally. And the first thing we would do is, if we got a proposal, we'd have to work through all these particulars, a few of which we've honed in on now. And I guarantee you on the drive home, I'll think of 3 more, right? But this is just a starting point. But you can see it's a very complicated process. where you're thinking constitutional law, state housing law, our code provisions concerning legal nonconforming uses. It's a bit of a labyrinth that we have to navigate, but we make sure we do that work.
Keith?
Yes, so there's a website dedicated, I assume you're referencing specifically the interim improvements occurring at Cherry Valley Boulevard. So there's a website which I think we have already linked on our city website, but dedicated to updates related to potential closures and the timeline for improvements to occur. And I'm wondering if my city manager's helping me out here.
Yeah,
with that link.
I certainly am. That website is improve10cv.com.
Thank you.
And then Kelly, would you pull up the map showing all the green space?
Yes. One of my favorite maps.
That one right there.
Yep.
Okay, Mike. The one on the right there, Kramer Canyon. Yeah, that was Kramer sold that. They did own it, and they sold it to the Conservancy. And I remember voting against it because I didn't think that we would ever get to use any of it. No. Correct. And all that other green stuff there on the left-hand side, that was part of the 6,000 acres that I think Oak Valley bought. And they, I don't know if they sold it or gave it. I think they sort of made trades and everything else. But they, you knock the, people knock development and things like that. Well, the developer, they have given up a lot to help us and to make the conservative happy, and actually take some of the environmental, that's called mitigation, I guess, is what you want to really look at. But they have given us things. Yeah, well, they gave us the property for it, so, and they did own the property, the city didn't. So that's all I wanted to point out. And do you have anything to comment on, sir?
Just one last thing that I'll add is that Kelly in the planning department do a regular development update that talks about different applications that are in the pipeline. So we plan on putting that on our website very shortly. We wanted to have this workshop first because we thought that having the context of what some of these things mean would be helpful, because obviously, there's transparency, but then there's meaningful transparency, and I think meaningful transparency is even more important. You can put a document out there, but if no one understands what it means, it really doesn't do much. But this at least will now give some context to what some of these things mean, so when you see something that's at a certain part of the process, now you'll have a better idea of what that means. So we do plan on putting that on our website very soon. That's all I've got. And thank you very much for everyone.
Yes, thank you very much for attending and staying awake for the whole thing. And thank you to the audience. And with that, I'm going to close this down and go home. Meeting. I don't know.